Hello, I'm Richard Palmer, a partner in the insurance team at Waitmans, and this is our third podcast on the implications of the Third Parties Rights Against Insurers Act 2010, which we'll call the 2010 Act for ease. As we've explained previously, there is a 1930 Act of the same name, but as the later Act will now apply to most cases, we're just going to be concentrating on that one here. You may have joined us after listening to the previous two podcasts, the first on the current environment around insolvencies in the market, and the second dealing with the applicable law and procedure from a practical viewpoint. If you've joined this podcast without hearing the others, then welcome, but do of course feel free to listen to the other podcasts on this subject first and then rejoin us. In this podcast, we're going to consider the strategic points that arise out of the 2010 Act. And along with my partners, Rob Crossingham and Alex Marler, we're going to have a chat about our experiences of the 2010 Act from the viewpoint of insurers and brokers. And as always, we hope to give you some practical tips that you can take away. We're going to look at this from the perspective of professional indemnity insurance, but it may well be that some of the tips and considerations have relevance to and can be adapted for claims under other types of insurance. The key strategic consideration is going to be the position you take as insurer to any policy coverage considerations that might arise. Any claim that a claimant now has against an insurer by virtue of the 2010 Act will only be as good as the right to indemnity that the insured would have had against insurers under the policy. As such, any policy points that exist could well reduce or even eliminate a claimant's right to an indemnity for its claim. Importantly, insurers cannot rely on an insured's failure to cooperate following the dissolution of the insured, and we've talked about that in the previous podcast, and the notification obligations can be met by the claimant in place of the insured. But as professional indemnity policies are written on a claims-made basis, any notification, whether by the insured or claimant, will need to be made in accordance with the policy and before expiry of the relevant policy, assuming it's not cancelled on or shortly after the insured's insolvency. So to the extent that coverage issues have been identified, what approach should you take as insurers? In particular, is there scope to take a harder line on those issues than you would otherwise have done if the insured had remained solvent and a paying customer? This would be with a view to providing you with a shield against a claim where you have a strong position, or assisting with your negotiating position where the merits are not so strong. And I suppose the place to start is whether there are any treating customers fairly, TCF or conduct risk considerations for insurers in taking a harder stance than would be taken if you had an ongoing solvent customer. If I can bring you in here, Rob, how do you think the FCA will view insurers taking that harder line?
Thanks, Richard. It's an interesting question. I think in circumstances where the insurer takes a harder line stance on coverage as against third parties than it might against a customer, and that genuinely does not affect the customer, the insured, it'd be rather difficult for the FCA to say that TCF obligations have been engaged. And so, yes, I think there probably is more scope to take a hard line in that type of third-party claim situation from a regulatory point of view. But for a variety of reasons, I think care obviously needs to be taken with this, not least because there's a possibility that any uninsured losses might reflect back onto the insured, either in its insolvency or against its officers and employees. And that may well engage TCF.
Right, thank you. No, that's helpful. And how would the position be affected, do you think, if there was an automatic runoff provision in the policy, as there are for some professions? Would that make any difference from a TCF point of view?
Possibly. It might put you back in the situation where you're just dealing with an uninsured, with an insolvent insured. I think an insolvency where you've got automatic runoff provisions would probably mark the cessation of a practice under that type of policy. So you wouldn't really expect an insured to be directly involved, and it might therefore be possible to take a hard line as discussed, particularly if there was no possibility of an uninsured amount reflecting back. But in reality, it's probably worth noting that policies that have automatic runoff provisions generally provide limited opportunity to take other policy points anyway, as they tend to be MTC policies. So that situation might be relatively unusual where you're looking at insolvency with an auto runoff provision.
One other important issue that might arise, particularly in larger or more complex claims, is whether it is in fact one claim or a number of them, and as such the number of applicable excesses. The insurer of an insolvent insured is not responsible for paying any excess or excesses, as we previously mentioned, And so it could reduce the insurer's overall liability if there are several claims and so several excesses. So in some circumstances, it will be attractive for insurers to argue against the aggregation of claims, as multiple excesses will mean less for the insurers to cover. At the same time, however, the opposite may be in insurers' interests. It may be in their interests to argue for aggregation of claims. This will be the case where the limit of indemnity is less than the loss. Better for there to be one limit than multiple. So we can see this is a complex area and it can go either way. The point is, I think, for insurers to understand that and consider it before settling on their policy position, to understand which argument will give which effect.
Just picking up on that point, Alex, about excesses and aggregation in this context of insolvent insureds, we've recently had to deal with a position where an insurance policy carries an each and every claim cost inclusive excess of around £10,000. The insured had made a block notification and there was quite a large number of claims, so the excesses would have amounted to quite a sizable sum, including funding defence costs. The insured, having made its block notification, was then unable to find renewal terms and so placed itself into voluntary insolvency, and within that voluntary insolvency made inadequate provision for its excesses. So as a result of this, the cost inclusive excesses per claimant in a substantial amount were not funded by the insured, and it resulted, of course, in the insurer's exposure to both damages and defence costs being potentially significantly higher, at least in theory. Of course, this brings in the practice of phoenixing, which is precisely what happened in my case, and is likely to be more prevalent, it seems to me, in the years and months to come, even though in heavily regulated sectors it's technically outlawed.
Thanks, Rob. That's an interesting point, actually. I think one other practical point that we're seeing is where a company has become insolvent, but its directors and staff have moved on, as you would expect. Files have been recovered from the liquidator, but they don't tell the full story, and it's clear that we're going to need input from, you know, the people who are involved in a particular project for us to have the best chance to defend the claim. Because the directors and staff have moved on to new companies, they want paying for their time, whereas insurers are pointing to the cooperation clause in the policy and saying that they want that time provided free of charge. And this can be particularly sensitive where a company has become insolvent because of an inability to renew its insurance. And in those circumstances, we've generally had to advise insurers that payment of reasonable costs is going to be required, as the obligation to cooperate is effectively removed by the 2010 Act. I think the key is working out what information you need from each witness and ideally getting that at an early stage to assist with the protocol stage. It also will help to inform the case strategy at an early stage. Is this one to settle, or can a robust letter of response be given, which might, coupled with the uncertainty that an insolvency event can bring, dissuade a potential claimant from proceeding?
Absolutely. And although it's always open to insurers to summons an uncooperative witness to attend the trial and give evidence, that's always a dangerous game if you don't know what the witness is going to say and they don't want to be there. Far better, if possible, to get them on side, get their buy-in. It will be cheaper and it will be more effective. You don't want the wrangling of witnesses to become a full-time job in the dealing with a claim and with a bill to match. Some witnesses will want to help anyway from a reputational point of view or a sense of professional pride perhaps, and to maintain commercial relationships. So wherever possible, we can try and tap into that softer side rather than trying to force the issue.
Yeah, and on a related point, Alex, thinking about the commercial relationship between insured and insurers and keeping talking to the insured, I've certainly seen and been involved in cases in the past where in advance of a planned or anticipated insolvency, an insured wishes to reach a deal with insurers. And we've been asked to advise on whether that's possible, and if it is, what such a deal should look like. And it raises questions about what effect that deal in terms of compromising the coverage position might have on the 2010 Act. there was a body of case law under the 1930 Act which dealt with the issues arising in this context where policy liabilities have been compromised between insured and insurer, and there appears to me to be nothing in the 2010 Act which would affect that. So in essence, where an insured and insurer reach a compromise on policy liabilities prior to insolvency and in good faith, then the third party will most likely be bound by that settlement, even if it's unsatisfactory from the third party's point of view. There's been consideration of whether in those circumstances third parties might take out an injunction preventing a settlement. But again, the case law would suggest that's only really an option on the rare occasion where there's evidence of collusion between the insured and the insurer.
That's a really interesting point. Thanks for that, Roll. So far in this podcast, we've viewed matters very much from the point of view of insurers being asked to defend a claim under the 2010 Act in relation to an insolvent insured. But of course, you may be in a position where the insolvent party is not your insured, but rather is a recovery target for you, with you having had to pay out money up the line to an ultimate claimant. You then effectively become the claimant, and all the points that we've raised above apply in reverse. So, Alex, do you have any thoughts on that based on your experience of this scenario that you could share?
Yes, thanks, Richard. I know we've all had some experience and successes with using the Act, as you say, as effectively a sword rather than a shield on the insurer's behalf. And it is a very useful tool. My recent example I'll outline is defending a design and build contractor regarding design defects in a building that had caused it to collapse. And defence of the claim had its challenges. Our contractor client obviously had taken on responsibility for the design and the construction of the building, and it had fallen down. But of course, the contractor had engaged subcontractors and consultants on the project. And so we looked to see what were the best targets to try and recoup as much as possible of our insurer client's outlay, our insurer client providing the cover to our D&B contractor, of course. Now, in our case, the engineer was the prime target and the steelwork subcontractor a secondary target, as it had some partial responsibility for certain parts of the design. Both had in the meantime gone bust, and we used the 2010 Act to ascertain the insurance position for each. We found out, as you'd hope and expect, that the engineer had PI insurance, and we also found out the limit of indemnity and the excess, and that the insurers had no credible grounds to decline to indemnify. There had been no breaches of fair presentation or of conditions precedent or anything else. And on that basis, we were able to advise our client that it was worth going after the engineer's insurers. And we did, and we got back for our client the vast majority of what they had paid out on the claim. In terms of the steelwork subcontractor, who we were considering going after for the shortfall, again, we used the Act to discover the position in terms of their insurance. Now, they did have PI insurance again, but on finding out who the insurers were and getting into the discussions with them, it became clear that they'd breached terms of their policy such that the insurers had a strong argument to not indemnify them. So, thrashing that out so far as we could with those insurers, we concluded that they did have a good argument to decline to indemnify. So with the benefit of that, we knew that this wasn't the fight to pick. We knew that it wasn't worth going after the steelwork subcontractor, as the insurance was simply not going to pay out. So save the client money by avoiding embarking on a fruitless exercise by pursuing them. We did maintain our argument that there was cover and that the declinature was invalid, and we did squeeze a small and fairly reasonable, in our view, pre-litigation settlement out of those insurers, which went some way to plugging the shortfall we'd had in the payout from the engineer.
Thanks, Alex. As you say, having access to that information about a party's level of insurance cover, whether that's good or bad news, helps to provide a fuller picture and to enable a cost-benefit analysis to be carried out before expensive litigation is undertaken. And that must be in everyone's interests. One can look at the filed accounts of a company, but not only will they be historic in nature, but also it's often the insurance cover that will be the determining factor on whether a recovery action is pursued. The fact that policy disputes between insurer and insured need to be highlighted is obviously invaluable in helping to carry out that assessment. One piece of advice that I can give, which we have used to good effect in the past, where a recovery target has insufficient assets of its own and has either not notified insurers prior to their insolvency or the expiry of the policy, or where there are identified policy issues, is to explore whether the target subcontracted elements of their work to others. So we had a case, for example, where we acted for a D&C contractor and its piling subcontractor went into liquidation. They had, however, appointed a consultant to design the piling, and we acquired from the liquidator an assignment of the subcontractor's rights against that designer, who we then pursued. And we managed to recover the full limit of that designer's limit of indemnity under their PI policy just by taking those simple steps. So it's always worth looking into this as part of your strategy. Rob, before we wrap up this session, are there any other points that you wanted to mention for our audience?
I think the only thing I would say really to conclude is to make the general comment that while some of this might seem rather dry or technical, against the general economic context that we discussed in the first podcast, I think that what currently seems dry and technical, I think will probably become very familiar to us. And there are really complex and sophisticated arguments and strategies and procedures that will become familiar as the time progresses at the end of the pandemic.
I think that's absolutely right, and certainly we are seeing a big uptick in claims under the Act. So that, I think that you're absolutely right, that is only going to continue, and people are going to become much more familiar with these sort of issues. So absolutely agree with that. Well, that concludes our third and final podcast on this topical and hopefully interesting subject. Hopefully you've been able to take away some practical and tactical points from our discussions. And I would stress that every case will be different. And so if you have anything that you'd like to discuss specifically, then please feel to get in touch with us. We would be absolutely delighted to assist. It just leaves me to thank Rob and Alex for their valuable input across the three podcasts. And thank you for listening.